to everybody. Welcome, dear candidate. Advisory group of experts today sits in full composition to conduct interviews with the candidates for the position of the judges of the Constitutional Court of Ukraine. And now it's time to start with the interview of a candidate, Mr. Tkachenko Oleksandr Vasilovich, a judge of the Commercial Court of Mykolaiv region, who has been allowed to participate in competitive selection process by the Council of Judges of Ukraine. The interview will be moderated by my colleague, Secretary of the Advisory Group of Experts, Yaroslav Romaniuk. That's why I'm giving the floor to him. Please, Yaroslav.
Дякую, пане голову.
Thank you, dear Mr. Chairman. Greetings, Oleksandr Vasilovich, and greetings to everyone who's watching our interview. All 6 members of the AG are present at the interview. The chair of AG, Mr. Alex Zeller, who participates in the interview remotely, online. Physically present members of AGE, Madam Hanna Sukotska, Madam Maureen O'Connor, Natalia Kuznetsova, and Oksana Vasilchenko. Also, the AGE deputy members in attendance, namely Thomas Griffith, Richard Barrett, Marek Zubik, Vasil Shakun, and Volodymyr Kuzmenko. And me, the AGE Secretary Yaroslav Romaniuk. Oleksandr Vasilovich, we had time to accumulate and to study certain data on your candidacy. We are grateful for your communication, for answering the questions that were of interest for us. But today, at this interview, we have gathered to give you the chance to clarify the moments that did not work, that were not completely clear for us, or perhaps to debunk certain doubts regarding the high moral qualities that exist for the judge of the Constitutional Court of Ukraine. Let me draw your attention to the fact that in accordance with the methodology, we are not going to consider the information or documents that you want to provide us today, or that you did not provide earlier, or the information that we requested but you didn't. We can make an exception only if there are good grounds for this. You'd understand me, right? I also would like to inform you that the interview is being recorded and broadcast live on the resources of the Advisory Group of Experts and the website of the Constitutional Court of Ukraine. Therefore, I call upon the AGE members and the candidate to limit the use of sensitive data and limited access information on live air. And we can only speak about the sensitive information for you or for your family only in this room, so that the information, it doesn't go anywhere beyond the limits of this room. The information or sensitive data or information with or limited access information. As for the duration of the interview, we plan to have it in approximately 1 hour. We kindly ask you to answer questions in brief, to formulate your answers clearly, so that you could respond to a question in 3 minutes. And some of the members do not speak Ukrainian, they are English-speaking members, and now we are having the simultaneous interpretation ongoing, and for your convenience, if you need to, you can use the headset. and use the simultaneous interpretation into Ukrainian language. At the end of the interview, we will give you the possibility to do the concluding remarks. You will have 5 minutes to do so. Agreed? Yes. And now we are ready to begin clarifying the answers that were not clear to us. So I will begin. Oleksandr Vasilyevich, in 2009, you have made the decision in the case in which you filed the complaint in Parma Ltd. while you were part of this car garage cooperative. Do you think there is conflict of interests? Yes, I think so. Why didn't you self-recused? This was my mistake. You participated previously in the competitions and at the interview with the Ethics Council in 2022, and you answered this question a different way. You said that you considered this case not to have negative consequence on the relationship with other persons of this cooperative. So, was this a mistake, or was it a conscious decision with the aim not to worsen the relationship with the participants of the cooperative? I do not deny, yes, I confirm those grounds in a different context, though. I just did not want to worsen the relationship with the members of the cooperative, but this does not exclude also the fact that this was a mistake. So my answer today is the same, just like when it was during the interview with the Ethics Council. But you, as a judge with a big experience of work, you do understand that it's insufficient for the judge to be independent, unbiased, in fact, but he should be considered as such from the point of view of the outside observer. Yes, I do understand that there are signs of violation of the rules for the self-recusal, and if I had the complaint back then and I was the member of the HCJ, I guess I would have recognized that fact. Okay, I see. Oleksandr Vasilyevich, in 2019, one of the regional courts of Mykolaiv, there was the decision made that was then what became valid, that obliged you, the garage box, yes, in this cooperative Parma. Did you fulfill this? No. Why not? Well, because we should not talk about the flaws of this decision, but this decision, in accordance with the legal position of the court and the law on the executive proceeding, the obligation is on the state executive service, but not me. So I was not obliged to fulfill function that is based on the civil executive service. Second, the letter that was issued for the decision to enter into force, it was not in line with the part of this letter. So this was like a forged document which was known to the state executive. By second, claimant has provided the document confirming that I had another property that was specified in the court's decision. Fourth, in the court's decision, there was mentioned the individually defined property that seemingly was bought 6 years before the legal entity was established. I could not have had the property that doesn't exist in reality, and I cannot return the non-existent property. But going back to the first reason that I gave, as for the decision in the indicative way was supposed to be done by the executive service, not by me. So for non-fulfillment of the obligations of the executive service, I was fined, and then they referred to the court on entering into register the crime. I'm so sorry, but I have to stick to the timing, and please pay attention. Do we understand correctly what you're saying? So you think that in accordance with this court decision, you were not supposed to take any active actions in order to put it into place, but this was the task of the executive service. Yes, exactly. Okay, so the executive service is studying the cases of the forced exercise of the decision. Why didn't you do it voluntarily? So one more time, the Supreme Court on one of the cases has specified if the court making the decision specifies in the decision, well, first of all, they had no right to specify two grounds, two forms of execution, demanding and forcing. Even if they are putting it there, it doesn't mean anything. And it doesn't deprive the executive service from fulfilling their duties. So if the court's decision has specified to oblige you, it means that you do not take any active actions, in your opinion. But you can only be urged to fulfill these actions by the the court's decision was not given for the fulfillment in the decision in the form that it was made, because they have extracted part 2 when that is said to obligate, and instead of to include of the executive letter the entire representation part when it's said to demand or require and then to force. I see. Next question will refer to the information that you have provided in the Declaration of Integrity. Such declaration is provided in Ukraine by the judge every year, and in period from 2016 till 2021, in the judicial integrity declarations that you filled out, you did not show that you, in 2016, were brought to the administrative account 2 times for the violation of traffic regulations. And in 2021, you were fined twice for non-compliance with the court decision. Why not? Why? Why didn't you show this information in the judge's integrity declarations? Well, speaking about first incident, I cannot remember exactly now, but since it is mentioned that I did not put it into declaration, during the interview with the Ethical Council, I knew this, that it said in one of the questionnaires that is part of my dossier, they had my message that I was brought to administrative account. But since I did not specify this in declaration, maybe because of the wrongful interpretation. It was my first declaration. So in 2016, your first one, but in 2021, not the first one. No, I mean the declaration per new legislation. Yes, but in 2021, 2 fines for failing to comply with a court decision, and you did not inform this in the declaration. Going back to Article 62 on the law on judicial system, which specifies that in the declaration, the judge is to specify to confirm the grounds which can have the responsibility. I think that legislation of Ukraine does not presuppose this if he did not fulfill the function of the executive service. Nothing like this is mentioned in the legislation. That's why I did not mention it. But this correlates with your previous position that the court decision does not oblige you to take active actions, but it was supposed to be done by the executioner. Okay. Oleksandr Vasilyevich, are you aware that the territorial management of the State Bureau in Mykolaiv, there was the criminal proceeding on Part 1, Article 332 of the Criminal Code of Ukraine, and it's avoiding fulfillment of the court decision. So what is the procedural status, your status in this criminal proceeding? For some time, I tried to find this out. And finally, the investigation bodies invited me, and they gave me the status of the witness. In the status of witness, I have informed witness that witnessing that I did not fulfill the court's decision, but I insisted on my interrogation in any status so that the investigative unit could study this and make the corresponding decision. So the procedural status of the suspect on Article 382, the pretrial investigation body did not set. No, and that's a very bad thing because I had no rights. If I had the status of the suspect, I would have some rights. But now the case has been investigated for 3 years, but the proceeding is not closed. Alexander Vasilyevich, next question will refer to the vessels Tkachenko for Winds, Dominic Stingray. As of 2011 until 2016, based on the order, you gained the right to use Tkachenko. Further on, as of 2020 until 2023, the 4 Winds. And as of 2021 and up till now, you have the right to use the vessel Dominic Stingray. Tell me, please, who are the persons who are giving you the right of use? Are they your acquaintances? Who are they for you? In our city, there is the organization that is doing the maintenance of vessels. And the head of this organization is a friend of mine. And no time this organization has been the party for the economic procedures. When I purchase some property or sell it, I do it via this person, telling me which power of attorney I have to obtain. As for Tkachenko, it's the property, Tkachenko, right? The property right. As for Tkachenko, the right of use. Okay, the right of use. In accordance with the explanation, but is it on the paid base? No. So it's free of charge? Yes. These, what kind of vessels are these? Tkachenko, it's the Soviet vessel that is 4 meters long, and others, Wind and Stingray, these are the American ones, and I took them for the time, for the summertime, for the vacation time. But what for? To go to for the vacation with my family. In accordance with the explanation of the NACP in the declaration, I should specify. Wait. Yes, indeed. My next question will refer to this. Why didn't you show the right of use of these vessels in your declarations? Because in accordance with the explanation of the NACP about the declarations, I should only specify this only if this property was in ownership for at least 6 months and was in my ownership on the last day of the period of declaring it. So on the 31st day, both vessels were in my ownership for 1 month, and on the 31st, they were not in my ownership, but they were returned back to this person who gave me the power of attorney, and that person has confirmed this to the Council of Ethics in the written form.
So you say that we should declare not the period when you are given the right of use, but when you use it actually. This is the conclusion of an ACP. I explained it in written answers. It makes sense. The next question is the block question regarding the cost of the car Toyota Land Cruiser, year of manufacture 2003. In your annual declarations for 2015-2022, you indicate that the price of this car is different. In one declarations, you indicated that the price is 161,600 hryvnias. In other declaration, it was 202,000. Why you mentioned differently the cost of the above car? I bought this car for $40,000, as I remember. But during the first filling in the declaration, I calculated in the wrong way. So I mentioned these $40,000. I put it in one document, but when I recalculated it in hryvnias, I'm sorry, so you bought it in and you paid in dollars? Which currency you used? US dollars? Yes. Is foreign currency can be the payment method in Ukraine? Yes, it is, it can be. And it is known that we can pay in hryvnias or in dollars. Yes, it is known, but as a candidate for the Constitutional Court judge should understand that it's unacceptable to make the payments in foreign currency. We have the only payment method. The only payment currency is hryvnia. It was 2008, so I wasn't a member of the Constitutional Court, but you were a judge. And do you think it is acceptable for the judge? But I provided a loan and I received a loan in dollars. Yes, loan can be done, but when we talk about the payment operations for purchase, it is not acceptable. So when you had interview with the Ethical Council, you acknowledged that you had indicated the wrong cost. However, in your declarations for 2021 and 2022, you indicated again the sum 161,060 hryvnias and not 202. Yes, because to make it faster, I take the previous period declaration and change it slightly. So maybe I haven't paid attention to the fact that there was the sum of 161,600 hryvnias, but then I corrected it. Yes, and it is acceptable by the law. Yes, it is like this. So you are holding the position of the deputy head since 2018. And in this period, since 2018, you participated different contests, like in High Qualification Commission of Ukraine, member of High Council of Judges. So the law prohibits to appoint for members of such councils being a member of administrative court institution. Have you been dismissed from your administrative position? No. And what is the sense? Because you know that you are prohibited to be appointed for such a position. So what is the sense to participate in the contest? I will inform you when we fill in the documents for the selection procedure, and the person who takes administrative positions, so that cannot be appointed as he or she submits the document for selection procedure. There are, even in the High Council of Justice, there are two different application forms. The one form says I have no restrictions, and the other form says that if I am selected, I will I will get dismissed. Yeah, but the law prohibits to select a judge like this. then I don't know why the High Council of Judges gives the possibility to apply and fill in all these two application forms. And this is the same for the High Qualification Commission of Judges? Yes? So then I shouldn't have been admitted for such selection procedure. And that's it. Thank you. It is clear, your position. So now we pass to the next question, and I give the floor to my colleague, Miss Maureen O'Connor. Please, Maureen O'Connor, please.
Thank you, sir. Good afternoon. Well, good morning. We're not afternoon yet. Good morning. I have some questions to ask you, but first, if you answered these questions previously with my colleague, I didn't understand them, but so I just wanted to go back and visit. Who owns the boats that you used during the summer at any time? Who owns them?
The owner is the person that is indicated in the power of attorney. I don't remember the surname, because the surname was provided for me from the person whom I know. She obtained this power of attorney from the owner, and she gave this power of attorney to me.
So you had someone else secure a power of attorney from somebody you've never met, and they never met you, and they owned all three boats. Is that correct?
Yes, the person who passed the power of attorney to me, this person could be the owner, or another person could be owner of these boats, whom I don't know. So power of attorney I could obtain from the person whom I know and from other person whom I don't know.
All right, so you don't know the owners of the boat, and you didn't pay for these boats, the use of these boats. Is that correct? Okay.
Yes. One of the owners was the person with whom I know. I don't remember, so he's the owner of which means which boat.
Wasn't the same owner for all three boats, or it was? I thought you answered initially that it was the same owner.
Maybe there was one owner, maybe.
And you didn't pay for any of the boats, the use. That's established.
Yes.
Didn't declare this free courtesy use. Is that true? Okay.
Yes. I didn't declare because of the explanation of the agency in vigor that explains. So this is the National Agency on Corruption Prevention. They give the explanation how to declare.
So you're reading that to be the limited use of it, time-wise, precludes you from having to disclose use of these boats. Okay.
Can I give you an explanation, small one? If it had been an automobile, for example, for automobile, the power of attorney is not needed. But as we talk about the vessel, about the boat, this power of attorney was issued. That's it.
All right. I'm not questioning the power of attorney, the need for a power of attorney, or the existence of a power of attorney. I'm questioning why the disclosure of this, some would say, luxury boats for your use by a stranger is not reported as your duty. And you say it was not necessary to be reported because it was a short period of time. Is that correct? All right. Okay.
Yes. I indicated the name, I indicated the explanation, I indicated the body who gives the how to declare, and I mentioned the statement why I decided to do like this. So I did it in conformity with the law, with the explanation.
All right, let's shift the attention to some property questions. In your response to the questions asked by the advisory group, you informed that since November of 2020, you inherited from your father an apartment, and the area is 34.5 square meters in a housing complex, Riviera. Please tell us about the circumstances under which your father acquired the apartment, and how was the apartment paid for? What were the sources of the money for the acquisition of the apartment by your father?
It was acquired in 2014, if I'm not mistaken, if I heard it correctly. I lived together with my father and my mother in the city of Kharkiv. In the city of Kharkiv, in our ownership, there were left two apartments, small apartments, and a cottage. My father has his own funds, and one of these apartments was sold, and this apartment in the housing complex Riviera, its cost was like 190,000. As far as I remember, I don't remember the exchange rate. So 100,000 was paid in one time, and then there was a loan, and we paid for it. After the first apartment was sold for $30,000, and the other apartment was sold for $24,000, and the cottage was sold for $16,000. So I obtained $70,000 from my father, and these were the funds to pay all the rest of the cost of this apartment.
By your father, you said. Yes?
Одна квартира була моя.
One apartment was mine. I don't remember which one. The other one was of my father's, and the cottage was owned by my father. But he issued the power of attorney to me for the sale and for receiving the funds.
Okay. So we have the fact that two apartments and a cottage were purchased by your father. He held on to them, used them. Did he use them, the apartments?
Ну, до того часу, як
Before I brought him to Mykolaiv, he lived in Kharkiv in one of the apartments. Then, when he moved to Mykolaiv, we sold this apartment that left there.
Did you ever live in these apartments?
ні,
Okay.
я
No. These two apartments with one room, they were exchanged. So we obtained them in exchange for the 3-room apartment that we obtained in 1976. Then it was privatized, and then we exchanged it for 2 one-room flats, apartments.
All right. Okay, in what year and for what amount did your father sell these apartments? You gave the amount in dollars. I heard $30,000 for one apartment, and then the cottage was $16,000. And what was the other apartment?
24.
The other apartment, $24,000.
Всі копії
I presented all the copies of the agreements and contracts.
Amount of money obtained from the sale of the apartments in Kharkiv was used by your father to buy the apartment in Riviera? Is that
Не
Is that
тільки
the
за цю
statement?
Не тільки за цю.
Not only for this sum, but also for the sum that my father had in savings as he has earned. And part of this, and also I gave him part of the sum. I don't remember how much did I give, how much did I contribute.
According to the records that have, come under our scrutiny, you claim that the amount of money obtained from the sales of the apartment in Kharkiv was used by your father to buy the apartment in Riviera. Part of it. Part of the sales price. Okay.
Да.
And so how could that be possible if the apartment in Kharkiv was sold about a half year later than the apartment in Riviera was purchased? In other words, the two apartments and the cottage were purchased by your father before he sold the Kharkiv apartment.
Я зрозумів. Давайте уточнимо.
I got it. Okay, let's talk about the dates. The dates when I purchased, when the apartments were sold, and when the Riviera apartment was purchased. I think we can do it if you have this document. If you can open it, we can see the dates. I need time to find out the documents. I know that one of apartments was sold before the apartment in Riviera was purchased. Should I find this contract?
Now you're saying one of the apartments was sold before the Riviera purchase.
Так.
Yes. Yes.
But what the information says is that the Riviera was purchased about a half year, 6 months, before you were able to sell the Kharkiv apartment. And yet you said the sale of the Kharkiv apartment allowed your father to purchase 2 apartments and a cottage.
Та ні, не 2 квартири та дача.
No, it's not correct. So we sold 2 apartments and a cottage. We sold them, not purchased. We sold together with my father. We sold a cottage and 2 apartments. One of the apartment, as far as I remember, had been sold before the Riviera apartment was acquired. So one of the objects in Kharkiv was sold before acquiring the Riviera apartment.
А навіть якщо воно не...
But even if they hadn't been sold, so the information that we have, Riviera apartment was purchased on the 4th of February 2013, and the Kharkiv apartment was sold in November 2014. And the second apartment, when it was sold, we should clarify it. Now we are clarifying it. So here I see the sale purchase agreements 13th of March 2012. Here is the sale of the cottage for this amount of... Yes, so the cottage had been sold before. Now I'm looking for the cost.
I will check now the cost. $140,000. My father and I got on March the 13th, 2012. That's for a cottage, dacha. Yes.
Or you purchased it? And what are you saying?
Продали.
Sold.
How much you sold it for?
140,000 hryvnias. And the first installment was paid as 100,000. I mean in Riviera.
Before the sale of the apartment in Kharkiv?
Так,
Yes. On March the 13th, 2012. And the apartment was purchased on the March the 4th, 2013.
The one in
знову
Kharkiv?
я квартиру. Я пробачаюсь, дача.
I'm sorry, cottage. The
Purchased, all right. Okay.
Ні, дача
No, the cottage was sold and Riviera was purchased. Please clarify in agreement of purchase and sale which amount did you get for selling the cottage? Point 4, item 4 of the agreement as of 2012, sale of the property is 140,000 hryvnias.
Pardon me if I'm not understanding and you're explaining. You use the word cottage, all right? And when you purchased the Riviera, that consisted of 2 apartments and a cottage, right?
Ні.
The Riviera? No?
Диві-
No. My father and I had 2 apartments in Kharkiv in another settlement. And also this cottage, let's call it cottage, it's the property near Kharkiv, in the outskirts of Kharkiv. Back in 2012, we sold this in the outskirts cottage and we purchased another one in the city of Mykolaiv, and this was the apartment in Riviera.
And then later you sold the apartment in Kharkiv.
А потім ще квартиру.
And then I sold apartments, yes.
The apartment in Kharkiv.
Ну от
Well, one of them I sold it in 2013 and another one in 2014. And when did you make payments for Riviera? Because you're saying that 100,000 installment was the first one, but when did you pay for this apartment completely? What are the sources of origin of the settlement for further payment? You didn't buy apartment for 140,000. No, for 190,000. I was paying. There was loan agreement according to which I was making the monthly installments, and it took me 3 years to pay for it. I had an amount 140,000 from the sale of the cottage, and then in 2013 we sold one more apartment, right? And we got the funds and used it for this. Alexander Vasilievich, could you please clarify one more time for which amount did you sell cottage? 140,000 hryvnias. That's item 4 of the agreement, because according to our information, the price is 62 2,685 hryvnias. And using the rate of dollar back then, it's like $1,600. Well, I'm taking my information from the notary certified document. Okay, I see.
40, and our information says 62,000.
Ну, напевно, я...
Well, probably. I don't know what information you have.
All right, let's move on to another. In your declaration for 2015 all the way to 2023, you say that since 2004, you've been renting a land plot. Your paper declarations for 2012 to 15 do not contain any information about the land plot. Could you comment on that?
Це
This is a typical violation, if we can call it a violation, of all those who submit declarations. The order for filling out the declaration until 2015 did not contain such a chapter or section where you could specify non-privatized land lots of the cottage. And this was the kind of land plot. And then when we could declare it in the declaration, everybody began to declare the cottages, houses that were not privatized, and correspondingly the land plots that they were using for these cottage houses.
Land on which the cottage sits.
так.
Yes.
And
Ну, якщо змінив,
And if the legislation has changed that further on required to declare such land plots, then I suppose the declarant had to respond to it and to declare it. I did. As of 2015, I'm declaring it. I see.
And you didn't declare it, though, from 2012 to 2015. Do you say that wasn't necessary then, or that's an oversight, that's an error?
Я не знаю.
I did not find a section in the declaration where I could include the non-privatized land plot together with the land plot where this cottage house was placed.
All right, I'm going to ask you some questions about your motivation letter. We'll leave the property. In your motivation letter, you indicated that one of the two motives for becoming a judge of the Constitutional Court of Ukraine, as for you, is, quote, the need to eliminate discrimination of judges and court staff depending on the court instance. In your written explanations, you have indicated your numerous applications filed with different state authorities and mainly referring to the qualification assessment of judges. Please tell us, what is the discrimination that you mention, and how could qualifications assessment of all incumbent judges as well as judicial candidates testify to discrimination? What's the nature and examples of the discrimination that you're referencing?
Так, по-перше,
Well, first of all, my statement about discrimination does not relate to my statements that refer to the qualification of judges, qualification assessment of judges. These are two different questions. They're not interrelated. The first question, discrimination. So as of the beginning, when Ukraine gained its independence, the first law on the judicial status of the judges was made, and 6 months later the discrimination began on the court instance where the judge operated. The first law envisaged that the court independence of the judge in the part of the court of the judge remuneration couldn't be different. So, in simple words, the salary of the head of the chairman of the Supreme Court could not be higher for more than 50% than the local judge. But 6 months later, certain amendments were introduced that gave the legislative and executive body by means of manipulation with the additional payments to make this difference 3 or 4 times higher. And this is a hidden discrimination that lasted until the last judicial reform. After the last reform, this hidden form of discrimination turned into an open form. So on the legislative base, this difference was envisaged. That is, by the way, is not in line with the opinion or conclusion of the Constitutional Court. Apart from that, as for the discrimination on the court instance, they also added the regional discrimination, where the remuneration for the judges differs for those who work in the city or in the region. The judges of Germany in 2005, they referred to the Constitutional Court, specifying that in different places, like regions, the judges get different remuneration. This is also the regional discrimination that we have. And back then, the Constitutional Court of Germany has admitted this was wrong, and they said to make it equal. But in my country, despite the fact that I have referred to all the bodies, all these bodies, they either are silencing it or not responding to it. By the way, presence of the discrimination has already been recognized by the Council of Judges, but they do nothing to tackle it. And also the High Council of Justice, that is also silencing it, despite my referral to this higher council for them to take any measures. And I did offer them the measures to be taken. One more thing, I referred to the Venetian Commission with this referral, specifying that when the Supreme Court got their salary decreased, the Venetian Commission somehow they gave their conclusion for 200 judges. So I wanted the same conclusion.
По суті запитання, чи ми правильно вас розуміємо?
Do I understand you correctly? Your aim to become the judge of the Constitutional Court lies in elimination of discrimination in the court system, using the example of the Constitutional Court in Germany. Yes, but I did not finish answering the previous question. I referred to the Venetian Commission, to the Supreme Court, where for Supreme Court, they have specified that this question actually was the violation of the Constitutional Court. So I also asked them or referred them to give the same conclusion for the protection of the thousands of local judges. And they told me that the Venetian Commission does not consider referrals of separate individuals. I gave a call and communicated with the committee, some organizational committee of the Venetian Commission, and I told them I did not refer as the private person, but as the deputy chairman of the local judge. Why didn't you give me the answer? But they said that I had insufficient authority. Okay, no, not this way. That it was insufficient for the deputy head of the local judge to refer, for the Venetian Commission to give the conclusion that you needed something more. For example, the HCJ, where I referred, but they ignore my referral.
You have filed applications with the Constitutional Court, the Supreme Court, the HCJ, etc. You've tried all of these institutions to have them address what you perceive as discrimination. So for my education, are you seeking that all judges be paid the same rate? In other words, a Supreme Court judge is paid what an administrative judge would be paid. Are you saying that? No?
No. First law on the status of the judge envisages that the remuneration of the judge of the local court can be half less than of the Supreme Court, so 50% less.
In place. And you think the
yes.
Tori? Do you think the formula is
Формула є.
No, there is a formula in place, but it has been violated by the latest law that was adopted, because now the judge doesn't get 50%, but 1/10 or maybe 20% as compared to what the head of the Supreme Court gets, instead of half. And the Constitutional Court said that this formula is to be applied. And it's not only what I recognize, also the HCJ recognizes this, but they don't do anything about this.
Salaries of the other judges, other than the Supreme Court, were reduced, is that true? Or the Supreme Court was increased? What was it?
Ні. Коли
When there was a promotion, when it was the advancement, the judges of the local court, they have, so finally, at the end, their salaries was increased by 3 times, but the Supreme Court by 7 times. And the courts of appeal more than 5 times.
You don't think that the legislation or whatever the source was to increase these salaries is appropriate, and this is your motivation to getting on the Constitutional Court to try and fix this, or to try and implement a prior decision of the Constitutional Court. Is that a fair statement?
не тільки для
Not only to do this, but including this. I want to, yes, to fix this.
Example of why you want to be on that court that doesn't have anything to do with salary.
Так. Добре, я скажу. Значить,
Okay. After the last judicial reform, the judicial reform is done not for judges, right? But it's done for people to get a fair justice. And after the last judicial reform happened the following thing. The judicial reform and procedural code, they limited and restricted the rights of the citizens to the cassation instance courts. But they provided insignificant cases that are not considered by the cassation courts. But they didn't give the cassation court, even if the first instance court has defined this case as not, is less significant. The Supreme Court recognizes independently, despite that the first instance court doesn't recognize this case as insignificant, the Supreme Court, not to take these cases, they recognize it as of low significance and they give it back to the citizen, also manipulating the conclusions of the European Court. The European Court says if the person applies with a cassation complaint, they require from these instances of other countries the cassation instance seeing this application, giving this person the possibility to reason why they think that it's insignificant, if it is insignificant, and why it should be considered by the cassation court. But they don't do this. They're just saying there's no grounds without even requesting or asking people why they think that these cases are of importance or significance for them.
You disagree with a reform that has been implemented because you think people's access to the courts is limited because of that.
Yes.
I think I've gotten to the end of the questions.
я
I'll
хочу
turn it back
таке.
to Mr. Roman.
But I want to clarify, I don't say that I disagree with the reform. I'm just saying that the Supreme Court judges are using the legislation in contradiction with the reform adopted.
Визнати неправильно.
You say that the judges themselves are misinterpreting or in some way manipulating the reform, the intent and the actual reform.
Yes, exactly. Exactly. And
You want to be on the court, the Constitutional Court, in order to oversee that and fix it.
Так,
yes, saying that the Supreme Court judges, they use the procedural code against the Constitution, yes.
Thank you.
Чи є запитання в
Do other members have questions? I have a question.
Я би хотіла, щоб ви все ж таки от пояснили мені.
I want you to explain from the point of view of the position of the previous question by Madam O'Connor. So, do you think that the provisions that related to the amendments to the procedural code in 2017, you consider them anti-constitutional? Well, you are motivating your wish to become the judge of the Constitutional Court in order to fix it. The Constitutional Court cannot change the legislation. That's the prerogative of the Verkhovna Rada of Ukraine. So I guess we should speak about and say that if these changes are inappropriate or non-efficient, then they have to be corrected by making amendments to the legislation, to the procedural codes that were amended during the judicial reform in 2017.
As Constitutional Court has another status. It is not the next resort after the Supreme Court. It solves another issues about the correspondence of Constitution to different provisions. So how do you think, being as a judge from Constitutional Court, how can you address these issues? So this question has already been asked to you by Ms. O'Connor. So in your motivation letter, you talked about the discrimination of judges on the court instance. This is the one question, we understand it. But when you disclosed your motivation, and the other question is more about the incorrespondence of procedural filters as determination of some cases as insignificant for not being considered in cassation courts. I would like to drive your attention to the fact that cassation court is the court dedicated to law, about the... If we talk about the law, if we talk about the facts, it's more about the appeal. So the legislation stated this procedural filter. So I would like to hear your motivation about the powers of Constitutional Court in this regard. So I will start from the Court of Law. When the Supreme Court doesn't admit the claim to be considered, the Supreme Court doesn't provide the admission, the unremarkable cases, small cases. Okay, let's stick to the Constitutional Court. Constitutional Court, when ratifies the decision and sees that there is no violation of the Constitution, but the norms of law are not used in compliance with the Constitution, there is the Article 89 about from the law on Constitutional Court. So we can apply this norm. Okay, there is the question from the chairman of the AGE, Mr. Oleksandr. Please.
Yes, thank you. I would like to ask the candidate to clarify his position with respect to the court decision which was not voluntarily implemented by him. In this case, which was decided by the Zavodsky District Court of the city of Mykolaiv, in this case, was you there in this case a defendant? So this was the litigation and you was the defendant in this case. Is it true?
Так, відповідач, захищач.
Yes, I was a defendant.
And is it true that this court decision took effect in end of February 2020?
Так, напевно.
Yes, I guess so.
So as a defendant, you was required by this court decision to give back the garage box, and you still believe that this court decision is not binding on you?
Ну, це
It's not that I believe it, but legislation of Ukraine says that this decision is done not through transition from myself. This is binding to the executive service, so executive service should do it. This is the first thing. And the judge that adopted this decision addressed the state bodies with the statement that there was false information, that the right of the ownership of the plaintiff was false. Like it was the agreement that this plaintiff acquired this property 7 years before this person was born. And by the way, as a participant of this selection procedure, I'm not only a subject of evaluation, but I am, as a person who addressed you about the violation of laws about the other candidate, Judge Tkachenko. I don't know whether you asked him about this fact, whether he thinks that the plaintiff obtained his ownership rights 7 years before, because the legislation of Ukraine doesn't say that the person in debt should provide the answer. Are there any other questions? If there are no...
Why then there are criminal proceedings initiated by the Territorial Office of the State Bureau of Investigation under Part 1 of Article 382 of the Criminal Code of Ukraine related to this case? Isn't this because of the intentional failure to comply with the court decision?
так. Але
Yes. And the Court of Appeal in Mykolaiv made it binding because they cover their decisions. Because in 3 years they didn't manage to give me a suspicion. So wasn't the question why they didn't present me a suspicion or close it? Because they understand that if they give me the suspicion, then it will be a crime, that it will be institution of liability, bringing into the liability, it's illegal. And if they close the case, there will be a shadow on the judges who had such a decision.
Are you familiar with Article 129(1) of the Constitution of Ukraine?
ну, знаю.
Yes, I'm familiar, but I can't. This is about the fact that the court makes a decision and the court decision is binding. I would answer this, that the lawful position of the Grand Chamber of the Supreme Court says that the decision is binding when this decision is taken in compliance with the law. If there are facts and evidence established by the court, and if there are evidence, and if there are no evidence, this decision has no force. And there is judicial practice in this regard. And another statement, we can't say that the judge isn't a person that is entitled with the same rights as other people. So Bangalore principle said that minimal guarantee of the just procedure is the right of the side to know about the evidence. So 6 years passed after this decision, and still I don't know what are the evidence that made the court to conclude that the person in 2016 has become an owner of this property that was mine. So, am I not entitled to know the evidence? Are there any other questions? If there are no questions, we ready to wrap up the interview, and now you are given the statement up to 5 minutes. I have a small question. Mr. Shakun, please. Tell us, please. For example, you became a constitutional court judge. Then you come to the vacation to Mykolaiv, and you take the vessels, the ships, the boat that you don't know whom they belong to. You pay in foreign currency. Is this the moral behavior of the constitutional court judge? I would like you to answer this question, as he is my deputy, and I confirm it. After this interview, I think that it doesn't correspond to the good moral behavior. If there are no other questions, we give the floor to the candidate for the closing statement. At first, I will start about this case about the garage. So when we talk about the respectful level of the judges from the Supreme Court, and it gives them possibility to recognize and to take a decision based on the false evidence, that it is their rule and their right. But I think that it's better for me to be non-integrity related than to be based on the false evidence. And the next one, when we talk about the discrimination, I think that society have heard about the issue of discrimination that is recognized about the regional instance and resort character, because we have to access to the European Union, and we should understand that it is unacceptable to have discrimination of judges, and it cannot be accepted by any European countries. That's it. Thank you so much. Thank you for your answers. And now the interview with the candidate for the judge of the Constitutional Court of Ukraine, Tkachenko Oleksandr Vasilyevich, is closed. Thank you.